Thank you, Mr. Chairman Bell, members of the committee. Thank you for the privilege of testifying here today on this important question. The importance, I think, is demonstrated by the number of people who've shown up and expressed their interest in it. I have 3 points to make very quickly. One, the 9th Amendment of the Constitution of the United States reserves to the people and states, and the 14th Amendment does not abrogate the power to specify and secure common law rights, which are those rights that Americans enjoy by virtue of ancient customary law and natural law. 2, among these ancient rights is the right to life, which in the common law is known as an absolute right. 3, the right to life is enjoyed by all natural persons, which includes unborn human beings, the aged, and infirm. Turning to my first point, the first duty of every state is to secure the rights that people already have. First among the rights that each and every person has by nature and the law of reason, before the first statute is enacted and before the first court renders judgment, is the right to life. The common law tradition that we inherited from Great Britain at the founding, which is incorporated in the United States and Tennessee constitutions, and which is still practiced by American lawyers today, is amenable to quite a lot of variation. But it has some important fixed rights. The common law contains a small number of absolute rights and inherent wrongs. In addition to the right to life, these rights include the right not to be enslaved and the right to keep one's limbs, while the inherent wrongs include intentional killing, maiming, and defamation. No state has just laws if it does not secure these absolute rights and prohibit inherent wrongs. And because states have an obligation to declare and secure absolute rights and to remedy inherent wrongs, they also have the power to do so. Now, apart from the absolute rights and inherent wrongs, the common law contemplates capacious room for self-governance by the people. Most of the common law consists of what the jurists call matters of indifference. Now, this does not mean that we should not care how infringements are remedied or about the specific contents of positive law. It's a term of art that means that those matters are left to be determined by courts, state legislatures, and private actors. Reasonable minds can disagree on these questions, and different states may differ on them. That is the jurisprudential background within which both the 9th and the 14th Amendments were debated and ratified. The Constitution contemplates that civil society and state legislatures will play the primary roles in specifying and securing the rights and duties of the people. States must secure absolute rights and prohibit inherent wrongs, and state legislatures may settle and specify those rights and remedies about which reasonable minds can disagree. Now, the Bill of Rights marks off certain rights as beyond the competence of Congress to alter or abolish. And much of the Bill of Rights has now been incorporated also against the state legislatures through the 14th Amendment. But as the 9th Amendment makes clear, the enumeration of certain common law and natural rights does not deny or disparage the other rights that the American people enjoy by virtue of natural law and their ancient customs. Chief among these, as I said, is the right to life. An absolute right in the common law tradition is one that a person enjoys prior to government, vested in him or her by the laws of nature simply by virtue of being human. That a right is absolute in common law terms means that governments are powerless to deprive any person of the right unless and until the person has been proven to have forfeited the right by committing some wrong, and that the wrong has been established in some proceeding that satisfies the requirements of due process. With respect to the right to life, this means that no innocent person may be intentionally killed. A person who possesses the absolute right to life is a natural person, a human being. The great common law jurist William Blackstone, whose commentary supplied the lexicon and lessons from which American jurists drew at the founding, and for more than a century thereafter, explained the difference between natural and artificial persons. Quote, "Natural persons are such as the God of nature formed us. Artificial are such as are created and devised by human laws for the purposes of society and government, which are called corporations or bodies politic." So a natural person, a person who enjoys the absolute right to life, is therefore any person who is formed as a person without the assistance of law. Obviously, this includes infants, born and unborn. Though a minor person does not yet enjoy all of the rights and privileges that human law confers upon persons, she cannot vote yet, for example, she is nevertheless already formed as a bearer of the absolute rights conferred upon her by the laws of nature. A minor person, like an adult person, possesses the rights not to be enslaved, defamed, maimed, and yes, intentionally killed. Now, in case there were any doubt, Blackstone expressly mentions unborn human beings in his chapter on absolute rights, which he places at the very beginning of the commentaries, chapter 1 of the first volume. And he makes it clear that unborn human beings are among the persons who possess such rights. The passage bears consideration in full. Quote, "The right of personal security consists in a person's legal and uninterrupted enjoyment of his life, his limbs, his body, his health, and his reputation. Life is the immediate gift of God, a right inherent by nature in every individual, and it begins in contemplation of law as soon as an infant is able to stir in the mother's womb." Still Blackstone. "For if a woman is quick with child, and by a potion or otherwise killeth it in her womb, or if anyone beat her, whereby the child dieth in her body, and she's delivered of a dead child, this, though not murder, was by the ancient law homicide or manslaughter. But the modern law doth not look upon this offense in quite so atrocious a light, but merely as a heinous misdemeanor." Still Blackstone. "An infant en ventre sa mère, or in the mother's womb, is supposed in law to be born for many purposes. It is capable of having a legacy, or a surrender of a copyhold estate made to it. It may have a guardian assigned to it, and it is enabled to have an estate limited to its use, and to take afterwards by such limitation as if it were then actually born." Unquote. Notice the features of the law governing unborn persons that are immutable, and notice which are subject to variation, which are fully determined by natural law and reason, and which are, in the words of the jurists, matters of indifference. Blackstone explains that the particular sanction for abortion has changed over the centuries. So has the set of civil rights that attach to unborn persons, such as inheritance and ownership. What hasn't changed, what is unchanging and unchangeable, is that the most vulnerable people among us are bearers of the natural right to life. As I said at the outset, the first duty of every state is to secure the rights that people already have. This Senate has the power to specify and secure the natural rights of unborn human beings because it has the obligation to do so. The Constitution of the United States does not say otherwise. Nothing in the 9th or 14th Amendment denies or disparages this right. To the contrary, these amendments expressly confirm what the law of reason teaches us, that all natural persons must be protected in their absolute right to life. Thank you, Mr. Chairman.